Good afternoon, and welcome to the Employer Link webinar series presented by McAfee and Taft. My name is Brad Neese, Managing Editor of Employer Link. Today we'll be discussing the next big compliance challenge with the Affordable Care Act, and that is new reporting requirements for employers set to go into effect for the upcoming calendar year. Our presenters today will discuss what steps employers need to be taking right now to get ready. Our presenters today are McAfee and Taft employee benefits attorneys Brandon Long and Barbara Klepper. Both work with employers of all sizes in designing, analyzing, and implementing cost containment strategies for company-sponsored health and wellness plans. Their areas of expertise also extend retirement plan design, deferred compensation, COBRA and HIPAA compliance, and the representation of clients in audits and investigations by the IRS and U.S. Department of Labor. They are both frequent authors and speakers on employee benefits issues for state, regional, and national audiences. Brandon also serves as practice group leader for the firm's employee benefits group. So with those introductions, I'll now turn it over to you.
Good afternoon, and thanks again for joining us today. Before this webinar, Barbara and I were looking over the registration list of the folks on this call today. And, from the list, we can tell there are a lot of folks that we've been working with on the player pay rules, helping to identify full-time employees, track hours, measuring periods, all of those crazy rules that we've talked about before. We've already done a webinar on that. For some time, we've kind of been saying and throwing out there that of equal importance to employers, equal to the player pay rules and identifying your full-time employees. One other topic that is of equal importance is the employer reporting requirements. We as the benefits community, has largely ignored up until now. And the reason is because they didn't issue final regs until just a few months ago on these reporting requirements. But if you think about it, the Affordable Care Act kind of has what we'll describe as some carrots and some sticks to help employers and individuals decide whether or not to have coverage and whether or not to offer coverage. On the the carrot side of the equation, they've got tax credits that they will give individuals who meet certain income levels and don't have coverage available to them through other means. On the stick side of the equation, you've got the individual mandate that requires individuals to have coverage or pay a penalty. And then you also have the employer mandate, which punishes certain large employers who fail to offer coverage or certain levels of coverage. And today, our webinar is going to focus on how the IRS is going to administer the stick side of the equation here so that they can compare individual tax returns with the information that they receive from employers and determine who to assess penalties on, including employers. Employers, for those of you on this call, we really need to be prepared and need to start working now to be able to defend any assessments that might come in the future. Again, we've kind of put this off as long as we can, but I imagine, the time that we've spent, think about the time we've spent with most of you in the last 6 months, year, or even longer, talking about identifying full-time employees. Going forward, I think we will spend a significant amount of time, maybe the same amount of time or similar amount of time, helping you to comply with these crazy rules. The reporting that will be required that we're going to talk about today will likely require you to pull information that is housed in different systems. I'm not a computer guy, other than I know how to call the firm's help desk, but I do have a sense that a lot of the information may be in different places. The information you will need ultimately to report to the IRS and to the individual employees. For example, your HR department might have information about who is offered health coverage, when they were offered the coverage, which months, and what they were charged. Your payroll system may have the information regarding the hours worked. And then there may be information that you don't currently have. For example, you may not currently have the Social Security number of your employee spouses and their dependents. And that will be information that you will need to comply with a piece of these reporting requirements that we will talk about today. So you may have to pull information that you keep separately right now from, for example, HR, payroll, and even new data, and kind of gather that all into one report and combine it in a way that you can report to the IRS and to the individual going forward. And so really this discussion today will help you kind of identify what we're talking about here, what these rules require, and then conceptually, I would encourage you as you kind of start wading into this as you have on the player pay full-time employee stuff, I would encourage you, reach out to us with questions, but also to get with your IT and payroll folks and, kind of start working as a task force to make sure that you're able to capture the data that you're going to need not only to report, but also to defend yourself if the IRS tries to assess a penalty on you. Okay, when will Affordable Care Act reporting be required? The first year will be 2015. If you recall, technically the rules reporting was first required in 2014, and they kicked the can down the road for us a little bit to 2015. And so what this means is, to the IRS, we will need to be reporting by March 31 for most of you that will file electronically, 2016 for the 2015 year. But if you think about it, folks, we're sitting here in July. Can't believe that it's already July. We're sitting here in July. It will be no time, and it will be January, and you will need the data starting in January, and then, of course, February, March, and so forth and so on for 2015 to be able to report in early 2016 to the IRS. And then kind of a corresponding requirement here, in addition to the IRS reporting requirement, is that you have to provide information to the employee by January 31 of the year following the year at issue. So, for example, January 31 of 16 will be the first time that you will have to report to an employee, but it will be for the 2015 year. We're going to first talk about, think about these reporting rules in two sections. There are two different requirements. One requirement is the individual mandate reporting requirement, and this requirement is designed to provide the IRS and individuals with information regarding minimum essential coverage and whether an individual satisfied the individual mandate. So if you think about it this way, if I was not employed, but I had if I had a fully insured medical plan from an insurance company, and this information would give me would provide me with a statement that I could take to the IRS and show them that I should not be subject to an individual mandate penalty. And similarly, if you think about it, if you are an employer who provides health coverage to your employees, you are the source for them to obtain the information that they will need to defend themselves against any sort of an individual mandate penalty. And then you will also be the source for the IRS to know who does not and who does have coverage. So on this slide, who must report? If you have a fully insured medical plan, it is your insurance company that will do the reporting that we're talking about in this portion of the presentation for you. So if you're an employer with a fully insured medical plan, this reporting requirement will be handled by your insurance company. For many of you, though, including, for example, McAfee and Taft, who are self-funded, you will have the reporting obligation that we're going to talk about in this section, regardless of the number of your employees. And so, in the player pay rules, we've talked a lot about who's a large employer that has to comply with the player pay rules that require you to offer a certain level of coverage or pay a penalty. And there, it's generally if you have 50 or more full-time equivalents. Well, here, for this reporting requirement, if you're self-funded, even if you had, let's say, 20 full-time equivalent employees, you would have a reporting obligation to the IRS and to the individual. Also listed here are some less popular or less common categories of folks, but people that are certainly on this call. For example, governmental employers are required to report on this coverage that's offered. And MEWAs, multiple employer plans, we're not going to talk a lot about that because most of the folks on this call fall into the private employer or government employer category. Okay. Generally, each separate employer of a controlled group has its own obligation. And what I mean by this is if you had a parent company ABC company and it had XYZ company as a subsidiary, each of those entities would have its own obligation. Entities can assist each other with the reporting obligation, but generally speaking, the liability, the obligation remains with each individual employer. You can hire third parties to help you with this, and I imagine there are folks out there who would help with this and gladly let you pay them to do that. But ultimately, as in a lot of things in our benefits world, the liability, the responsibility remains with you. Who's not required to report? As I've already mentioned, employers who sponsor fully insured health plans are not required to report under this requirement, but they will be required to report if they're a large employer under the requirement that we'll talk about in a minute that deals with the employer mandate reporting. But for here, a fully insured employer is not required to report for the individual mandate category. Employers who have HIPAA-accepted self-funded coverage, an example of that might be an on-site medical clinic. HSAs that are provided in connection with a high-deductible health plan. The preamble to the regs states that HSAs are not required. There's no reporting required for the HSA by itself, and similarly for HRAs. I'm going to let Barbara talk about, on this next slide, about what will be reported to the IRS, and we'll talk again in just a minute.
So this is really just the nuts and bolts of the actual form and what you need to be thinking about as an employer to be gathering at this point for purposes of next year so you can be fully prepared. The first piece of it is the name, address, and employer identification number, that EIN that you use on so many other forms, of the reporting entity itself. That shouldn't be too much trouble for most of you. The next piece of it might be a little bit more difficult. It's the name, address, and Social Security number of the responsible individual. The responsible individual here that we're talking about is the primary insured employee or former employee, so the person who is actually working for you and for whom you're providing benefits. Now, a little piece about the Social Security number. The regs went into great detail about when you can use it, when you can't, and what happens in cases where you maybe don't have it. And we'll talk about this, too, for the next piece of it. But generally speaking, you need to have the Social Security number. We have on here that you can also use the date of birth if it's not available. That is true, but it's only true if you have first made great efforts to get it. And by great efforts, really it's just an initial request for the Social Security number, and then one more request for the next year if you weren't able to obtain it successfully. And by doing so, you will have satisfied your requirement to make what the IRS has called a reasonable effort to obtain it. And then you can use the date of birth if you don't have it. Moving on to the next piece of it, you also need the name and Social Security number of all the individuals who are covered. And that's what Brandon was talking about. You may not have the individuals, for instance, the spouses or dependents, Social Security numbers previously to these requirements. So that will be one piece of information that you're going to want to look at for next year and start working towards those steps of either asking for it next year or knowing that you need to follow up with maybe questions that you've already asked for the previous year.
And just on that point, it looks like they're in terms of trying to obtain a dependent's or a spouse's Social Security number, and Barbara already mentioned this, but just to highlight the point, you may have to make several efforts to obtain that information from both the employee and from the dependent, and the efforts might need to span over a couple of years. So this is something that, in particular, when I was looking at these rules, surprised me. It shouldn't have, but it did. Honestly, that is the information that we will need, because I know a lot of you, including our firm, frankly, I don't think we necessarily have that information, and if we do, it's locked down because it's only needed for certain very limited purposes. So I think that's one piece of information we definitely need our employer clients to be zoned in on trying to obtain as we work towards reporting in 2015.
And just one more point about the Social Security number, not to talk about it too much, but you are able to use a truncated version of it when you actually do report. So you can use the last four of the Social Security number just like you would hope to do to the extent that anybody has issues with privacy on that point. So moving on, you also have to report the months during the calendar year when the individual, the responsible individual again, was covered. And here we're talking about not exact dates necessarily, just the months. And moving on to insured group health plans, you have to provide the name, address, EIN, and the employer. And then also for insured group health plans, whether that coverage is qualified through the SHOP, the Small Business Health Options Program, exchange, and the SHOP's unique identifier. The form of IRS reporting for applicable large employer members only, is that the 50 or more full-time employee equivalent. And for purposes here, remember, too, we're talking about all in the control group, is the Form 1094C and Form 1095C. That's for both self-insured and insured. For the reporting entities who are not applicable large employers who do not have the 50 or more full-time equivalents, we're talking here about Form 1094B and 1095B. And Brandon and I were talking yesterday about the fact that the IRS has still not provided us with those forms. So we're still waiting on that. Not completely surprising. For the electronic reporting, you will be required to do this if you, as an employer, are required to file at least 250 of the specified form. And what we mean here is 250 of the, for example, Form 1094C or 1095C itself. So we can't combine the forms and say we're required to file 250. For instance, if you have W-2 requirements, and obviously now you're going to have the 1094C and 1095C requirements, you can't say, well, I have 100 1094Cs and I'm going to file 100 W-2s, so I'm good to go. We're not aggregating here. It's just for that specified form. The timing of the IRS reporting we've kind of touched on, but just to mention one more time briefly, we have to do by March 31st of the following calendar year or February 28th if you don't meet the electronic filing requirements. And here we're talking about the same requirement for both calendar and non-calendar year plans. So if you have a July 1 calendar plan year, for instance, we're still looking at all of the months for the previous calendar year only, not your plan year. So that's something to consider. And we've talked a lot about the actual form that goes to the IRS, but now we're going to talk about and kind of shift over a little bit to the statements to individuals, which is another piece of these reporting requirements that we're going to need to be completely prepared for. And the statements to individuals largely mirror the requirements to the IRS, mainly because you're able to, in certain circumstances, use the form that you send to the IRS to also send to the individual. But there are just a few little nuances, so we'll kind of go over those one more time. Remember, here we're talking about providing the statement to the responsible individual, and similar to the requirement for the form to the IRS, the responsible individual is the primary insured employee or former employee. There's no requirement to provide a statement to anyone else other than the primary employee or former employee. So no requirement to provide statements to spouses, beneficiaries, dependents, anybody else that you might be able to think of, including the people that you need to get the Social Security number information for. This is not for the statements to individuals, which is a little bit of a relief. The statement to individuals' content, like I said, is the same information that needs to be sent to the IRS. And again, we've got the Social Security number or the date of birth, depending on whether you were successful in obtaining the Social Security number. You can also use the last 4 digits, just like we talked about before. We're also talking about the months here that the responsible individual was enrolled in coverage. Again, not the exact dates, just the months. The phone number of the contact person at the reporting entity, and, if applicable, the policy number of the plan. The statement can be made by furnishing the individual with the same copy of the return that was filed with the IRS, which is some relief. We don't necessarily need to recreate the wheel here. You'll be able to just hopefully provide them with the very same form should you choose to do so. The timing of these statements is sooner than it is for the form to the IRS. So whereas we've got a March 31 or February 28th deadline for the IRS form, we've got a January 31 deadline for the statement to individuals. So even though you can use the same form, you need to have that form ready to go if you want to use it so that you can send it to the individuals earlier. The same schedule applies here that applies to Forms W-2 and 1099. And you can also request an extension if you choose to do so, but keep in mind here that the extension is only going to be for 30 days, and you also have to establish that you have good cause for requesting the extension. Again, 30 days is maybe not worth it to file an extension, but in some cases it might be. You will have to meet that good cause standard, though, so something to keep in mind. And then lastly, for my piece of the individual statement is the manner of delivery. You can send it to the last known permanent address of the employee, and if there is not a permanent address or if you don't know it, then you can send it to their temporary address or some address that you have in mind that you know would be a reasonable place to send it. So if you know that they've moved and you don't know exactly where it is, but they're staying with a buddy, you can send it to the buddy's address and you'll have met your requirements. The first-class mailing satisfies the statement obligation, even if that statement is returned. So if you do everything you're supposed to do and send it out via first-class mail, and that form comes back to you, then you have met your obligation, and you don't need to be so concerned about trying to, send it again or obtaining a new address, which is a little bit of a relief. And here, the electronic delivery, we have electronic delivery rules and requirements that apply to lots of different forms with the IRS and the DOL. But here, you are only permitted to deliver it electronically via email or other forms if the participant or employee affirmatively consents to receiving it via electronic mail. So if you, for instance, wanted to have the employee sign a consent form to satisfy this electronic consent delivery requirement at the beginning of open enrollment or when they first start, however you want to do it, that might be a good idea so that at the end of the day, you're not subject to this affirmative consent requirement and you get dinged. So I think Brandon is going to talk now a little bit about the penalties that apply to both the forms and the individual statements.
Thanks, Barbara. One thing on the last point that Barbara made, which is an important one, especially for those on this call who are attorneys or benefits consultants, typically we have this general idea, and it's a correct idea, that you can deliver something electronically to an individual if they use a computer as a part of their job and they're required to. That is not present here. So for those of you who are used to that kind of familiar rule, especially those of you, again, that advise clients about these kinds of issues, be careful here because, like Barbara said, electronic delivery is only permitted with consent. That rule that we all work under does not apply in this context. One other thing I wanted to kind of, we've kind of beat the fact that you need a dependent Social Security number a lot, but I want to give you an example that might give you an idea of what we think is going to be required here for that point. Before we talk about more of the sticks and penalties, let's pretend that McAfee and Taft employs Brandon, and my 21-year-old son Cameron is covered under the McAfee and Taft medical plan. McAfee and Taft realizes they don't have my son Cameron's Social Security number. So in December of 2014, Judy Cross, our HR person, asks me for Cameron's Social Security number. I ignore that. Then, prior to the following year, Judy writes a letter to Cameron and asks him to provide his Social Security number directly. He ignores that request. And so then, when McAfee and Taft files its return in early 2016 for the 2015 year, it reports Cameron's date of birth in place of his Social Security number. 1 year later, prior to December 31 of 16, McAfee calls Cameron and asks him to provide his social. Cameron again ignores the request. And so if you think about it, we've had multiple attempts, which is what will be required of you, to obtain a Social Security number. And because of the second follow-up, McAfee no longer has any obligation to continue to try to solicit and obtain Cameron's Social Security number. But it's not just a send a letter and move on. There's going to have to be multiple attempts. And so I know that we've mentioned that a couple of times, but I think that's a big deal. On the penalty side, penalties may apply if there is a failure to make a return to the IRS or to furnish a statement to individuals. And very generally, penalties may be up to $100 per return with a maximum of $1.5 million. Waiver is available where failure is due to reasonable cause and not willful neglect. You can reduce the penalties if they're corrected within 30 days of the required filing date. For 2015, they provided a limited amount of relief if you file a return in good faith, but it's incorrect. Unfortunately, if you just flat out fail to file, the limited relief for 2015 does not help you. Okay, we're going to talk now. We're shifting gears into the employer mandate reporting and what's required to comply with that. This reporting requirement applies to those of you who have more than 50 full-time equivalents. Those of you who've been focused on identifying your full-time employees for 2015 and beyond. If you have less than 50 full-time equivalent employees, these reporting requirements would not apply to you. The IRS needs certain information to determine when you have offered coverage, who you offered it to, how much that coverage cost, and that information will allow them to determine whether you, as an employer, have satisfied your requirement to either offer coverage or pay a penalty. It will also help the IRS administer an individual's eligibility or lack thereof for subsidies through the exchange. Okay, who must report? As I mentioned, a large employer that had 50 or more full-time equivalents during the prior calendar year. So if you had 50 or more full-time equivalents in 2014, you are a large employer for 2015. And again, the requirements apply to each member of the control group. So back to my example, let's say ABC Company has 9 subsidiary entities that have separate tax ID numbers. Each of those entities is separately required to report on the employer reporting requirement. And if you think about it, it makes sense because the way the player pay penalties work, as you guys know, is that the penalties kick in if each member of the group fails to offer that entity's full-time employees, or 95% of that entity's full-time employees, coverage. Obviously, there's some transition rules that apply that are beyond the scope of what we're talking today in terms of the player pay penalties. But if you think about it, the reporting requirement applying to every member of the control group makes sense given the way the player pay rules work. What has to be reported? The name, address, and tax ID number of the employer, the name and telephone number of a contact person. This could be a third party. If you have a third party that's going to help you with this, or your consultant, for example, I think that would be fine. The calendar year for which the information is reported. Number 4 on the slide, certification as to whether you as an employer offered your full-time employees and their dependents the opportunity to enroll in minimum essential coverage by each month during the year. Number 5, the months during the calendar year for which coverage was available. Number 6, for each employee, that employee's share of the lowest cost premium for self-only coverage. And again, this is a calendar month reporting obligation. Number 7, the number of full-time employees for each month during the year. If you are not tracking accurately your employees and who is and is not a full-time employee, you will not be able to comply with these reporting obligations. And this is why, the player pay rules that we've been focused on in identifying your full-time employees are so critical, because not only do they matter for purposes of determining who you offer coverage to, they'll also matter for purposes of these reporting rules that we're talking about. Number 8, I want to talk about this one a little bit more. I'm not going to talk any more about the fact that you need a Social Security number for dependents for the individual reporting requirement that we talked about. But it's you have to provide that information for each full-time employee for each month. And on the individual mandate and the reporting that goes into that we talked about just a few minutes ago, if I'm an individual and I have coverage one day in a calendar month, I am deemed to have coverage for the entire month. In this context, for this reporting rule, it's different. And so the information that you will need, and this goes back to getting an early start on this, there are some nuances between what you need for the individual mandate reporting and what you need here for the employer reporting, because on the employer side, an employer is only deemed to offer branded coverage for the month of January if coverage was offered every single day of that particular month. And so you're going to need to know for every employee which months they were offered coverage, and to satisfy that, you're going to need to know which days they were offered coverage. There are some strategy issues that your consultants and lawyers can help you with to comply with this, but this may not sound like a big deal, and it sounds like a nerdy nuance. I'm real good about getting into the weeds on nerdy stuff, but it illustrates that there's some complexity here that would be easy to gloss over. I feel like I beat up on consultants when I talk on these presentations, but I'm a big believer in letting your consultants help you with a lot of these rules, because all of you have other things that you do, a lot of other things that you do besides just employee benefits. And so trying to deal with the complexity and nuances that apply here, I think would be overwhelming on your own. Number 9, there could be other information that the IRS ultimately requires through different publications. In addition to the specific information that is required, certain other information will be required through what they call indicator codes. It will be interesting to see. I think it'll help all of us, me included, understand all of these reporting rules once they issue these forms that they've yet to issue yet. But it will be interesting to see how the indicator codes work and what that means. I would think that there would be spaces on the IRS form that you fill in certain codes to identify, for example, whether coverage was not offered to Brandon during the month of January because I was in the middle of a waiting period. Some of the other information they've indicated will be reported through indicator codes, includes information as to whether the coverage provides minimum value and whether that employee had the opportunity to enroll his or her spouse, total number of employees by calendar month. Another code that we didn't list here on the slide, and again, I don't know what this will look like yet, but there's some indication that they will want us to report on our control group. Who's in our control group, if there are other entities in our control group, and if so, provide information regarding who those other control group members are. And just back to the, kind of the basics, a control group is generally, very generally, an entity that is owned, at least 80% of the ownership is owned by another entity, but you can have a control group in other ways as well. So to report on this information, you will need to understand the control group rules that are applicable to your particular group of entities. Form of IRS reporting, it's similar to the W-2 concept. It's helpful for me just conceptually to think about it that way. Every employee will have a W-2, and it will be, it's something you file with the IRS. It will be the same here. Every person will have a statement, an employee return statement, and that will be that 1095-C, and then you will use a 1094-C to transmit that information to the IRS. In the proposed regs that were issued early on, there was a little bit of concern that you might have to use separate forms to comply with the individual reporting requirement and the employer mandate reporting requirement. But in the final regs that were issued a few months ago, they made it clear that you're required, if you're a self-funded large employer, you're going to be required to use the information needed to comply with the individual mandate reporting rules, which we talked about first, and the employer mandate reporting requirements, which we're talking about now. You'll be required to report both of those on the same form. And think about it, too. If you have 50 or more full-time equivalent employees, but you're fully insured, remember, if you're fully insured, the individual mandate reporting doesn't apply to you. But if you're a large, fully insured employer, you will only complete one portion of the Form 1095-C to reflect your compliance with the employer mandate. Again, electronic, similar to the rules that Barbara talked about earlier, electronic filing is required if you are required to file at least 250 of those Form 1095-Cs. Timing is the same as what we discussed earlier, by March 31 of the following year, and the same timing applies to non-calendar year plans. You know, the IRS, in terms of assessing penalties, especially as to individuals report on a calendar year basis, and so the fact that an employer might have a non-calendar year plan is really not relevant to the IRS for purposes of assessing penalties and determining tax credits. That's why they have kind of made it consistent so that everybody's reporting on the same schedule. Okay, I've already mentioned large employers that are self-funded are subject to both the required individual mandate reporting and the employer mandate reporting, and you will use the same Form 1095-C to comply with both. There'll just be different sections on that form.
Now we're going to talk about the statement to individuals, and just like we had for the individual mandate, the employer mandate reporting requirements also contain a requirement to send a statement to the individual. The difference here being that you send the statement of individuals now to the full-time employee. So previously when we were talking about the individual mandate, we were talking about sending it to the responsible individual, who, of course, was the former employee or employee. Here we're only talking about full-time employees, so a little bit of relief. There's no requirement to send the statement to non-full-time employees, so part-time employees, seasonal employees, full-time equivalents, all of those people that you have been looking at and measuring for the previous year. For purposes of the employer mandate only, we do not need to send them an individual statement. And of course, there's no requirement to provide a statement to non-employees, so independent contractors, anybody that you might have coming in. The required content of the statement to individuals is, again, the same information that's going to be sent to the IRS on the return, so that 1095-C information. You do not need to send the transmittal form that you use, the 1094-C. You do not need to send that to the individual, but just like it was for the individual mandate, we've got the name, address, and EIN number of the employer. Moving on to the timing for the statements to individuals, these statements need to be provided no later than January 31st of the preceding calendar year. This is the same as it was for the individual mandate, too, although fully insured employers were not subject to the individual mandate. So tune in if you sponsor a fully insured plan. The same schedule, like Brandon was talking about, that applies to Forms W-2 and 1099 applies here as well. And just like Brandon mentioned, the reason for not really caring about non-calendar plan years is because we're talking about employees, and similar to the W-2, we're looking at a calendar year basis. So you're looking at the previous year. So, for example, the first employee statement that will need to be provided is going to be required to be given on or prior to February 1st, 2016. That's only because January 31st is a Sunday that year, so otherwise it would be January 31st, 2016. And that would be for coverage and the employer status related to the 2015 calendar year. The manner of delivery, again, similar to the individual mandate, we're sending it to the last known permanent address or temporary address if the individual doesn't have one. Again, we're only talking about the full-time employees. Keep that in mind. And you can include the mailing, which is good news. You can include this statement in the same mailing as the W-2. So we've been comparing the individual statements and the Form 1095-Cs to the requirement to provide your employees with a W-2. Well, you can also include it in the same mailing. So to the extent that that helps you conceptualize and keep things together as to what full-time employees especially will be required to receive, they'll get their 1095-C statement alongside their W-2 if you choose to provide it that way. Again, here, the electronic delivery is only permitted with their consent. So you may consider and think about having them at some point during the year sign a form or otherwise provide their affirmative consent to receive electronic delivery of these statements if that's going to be easiest for you as an employer. The general electronic delivery rules are not applicable. It's a little bit of a nuance and a little bit of a headache that Brandon was talking about earlier. The penalties here are also the same. Just to say it one more time, we've got up to $100 per return with a max of $1.5 million, and a waiver that would be available if you are able to, as an employer, establish reasonable cause for the delay, which has a whole slew of little nuanced rules that go along with how to establish reasonable cause. But keep in mind that it's not simply a matter of forgetting to file or not filing. You really need to have a very good, strong reason. And for 2015 only, we have that requirement that you have to file, but you might be okay if it is not correct. Again, simply failing to file won't provide you any sort of relief. I'm going to jump into, at the very end, the alternative methods for satisfying the employer mandate. These methods are rules that the IRS gave us in these latest and final regulations that may be used as an alternative to filing the 1095 and 1094 C or B forms. And it's unclear whether they will be widely used. And to be honest, the rules are a little bit convoluted, as you can imagine with all of these reporting requirement rules. They are complex, and they won't apply to all employers. There are very specific circumstances in which they will apply, and I will briefly mention each of them. But if these are something that you may be interested, I really urge you to consult with your consultants, anybody that might be advising you on these reporting requirements to see if these actually do apply to you. Because again, unless you meet very specific requirements under these alternative methods, then you will be subject to the default method of actually filing the form and providing the individual statement to the employees. And that may cause a bit of a headache for you if you thought you were otherwise able to use these alternative methods. So just very briefly, the first method is the reporting based on certification of providing a qualifying offer, and what's known as a qualifying offer of coverage. That is simply providing for all months of the year coverage to full-time employees that was considered minimum essential coverage and provide a minimum value. And so that's also, to full-time employees and their dependents. So if you are able to certify that you did that and that minimum value did not exceed 9.5% of the federal poverty level for those, as to those employees and dependents, then you may be able to just certify on that Form 1094C that you did so. This is not available in certain circumstances. For instance, if you are a smaller employer with 50 to 99 employees and you're using that 2015 transition relief for reporting, this is not available to you, which is another reason why I urge you to consult with your consultants on this, because it really could cause a headache if you think it is. And also, the other thing that's a little unclear under the regs is the fact that you need to also provide the employee statement. So even if you're able to use this alternative method of certification of the qualifying offer of coverage, you still need to provide your employees a statement. So the second alternative method is for employers that offer 98% of their employee workforce health coverage. And this is called the quote-unquote 98% offer certification. So again, you have to certify on that transmittal form, that 1094C, that you do as an employer provide most of your employees coverage. And this would be especially helpful if, for instance, you didn't want to count the number of full-time employees that you had or their hours for the previous year, because simply you provide coverage to mostly everybody. And you can be absolutely certain that the people that you do not offer coverage to are not full-time employees. So again, some nuanced rules there. And then there's another alternative method for the transition relief certification, if you're eligible. That was that 50 to 99 relief that we were talking about for those certain smaller employers. You will be able to certify on the transmittal form to the IRS that you do qualify for that transition relief, and then there's certain reporting requirements that would pertain to you as an employer as well. So, again, these alternative methods are unclear as to whether they're going to be widely used. I think, judging from the way that the regulations read and the extent of the regulations on the actual forms themselves, that the majority of employers will probably be using the forms that will be provided. It seems that those rules are a little bit more clear. But again, if you are interested in one of those alternative methods, then get with your consultant or us or anybody else that might be advising you as to these reporting requirements, just to make sure that you actually and absolutely meet all of the requirements for those. So that pretty much sums up the reporting rules in a nutshell, and we appreciate you tuning in for the entirety of this. We know that it is convoluted and a little bit difficult to completely ascertain and understand. And as Brandon was mentioning at the very beginning, we've really been able to take a back seat when it comes to these reporting requirements because we simply haven't had the rules for which to explain them. But now we do, and now the 2015 is really going to be the mark for which we need to have everything in place, all of our ducks in a row come January 1, so that we don't get dinged as employers on January 1, or come 2016 because we weren't ready.
I want to again thank Brandon Long and Barbara Klepper for presenting today's webinar. And on behalf of the law firm of McAfee & Taft, thank you for joining us for another Employer Link webinar. See you next time and have a great afternoon.